This exchange wasn't about the Trump investigation, at least not directly. It was about something much older: credibility, pattern, and memory. In just a few minutes, a congressman from Wisconsin attempted to put an entire career on trial, not with new evidence, but with a carefully arranged sequence of past controversies. So the real question isn't what Jack Smith said here, it's why this particular history was chosen to be retold, and why now. This questioning follows a very different strategy than the previous exchange. Here, the congressman doesn't rely on moral analogies or emotional appeals. Instead, he constructs a resume-based indictment. The opening question is simple and factual. Did Jack Smith work at the Obama Justice Department in 2010? Once Smith confirms this, the structure becomes clear. The goal is not to dispute the current case, but to anchor Smith's present authority to past institutional controversies. The mention of Lois Lerner and the IRS is deliberate. This reference immediately activates public memory of perceived government overreach, even before any direct accusation is made.
Yields back. The gentleman from Wisconsin is recognized.
Thank you, Mr. Chairman. In 2010, Mr. Smith, did you work for the President Obama's Department of Justice?
Yes, in 2010, I was the chief of the Public Integrity Section.
During that time, did you have any contact or connection with Lois Lerner with the Obama IRS?
Yes, I was new to the Public Integrity Section. I was the chief. I was trying to learn about issues I had not been at.
Did you attempt to work with Lois Lerner and the IRS to investigate nonprofits?
What I did was I asked for a meeting with the IRS about nonprofits.
So the simple answer is yes. Correct.
Well, I didn't ask to work with Ms. Lerner. They sent Ms. Lerner. That's the person who came to this meeting. I met her once.
And they went after Second Amendment groups, correct? If you remember correctly, that's what was the offshoot of it, that Second Amendment groups that tried to gain nonprofit status, they were slow-rolled through the IRS. Do you recall that?
Separate from this, there was an investigation of that that I was a part of in Public Integrity.
Did you, you prosecuted Virginia Governor Bob McDonnell, this was asked earlier. You prosecuted him, correct?
I was part of the prosecution, yes.
And that ended up with a, that decision ended up being unanimously overturned by the Supreme Court, correct?
That is correct, sir.
Yeah, including Justice Ginsburg joined in on that opinion, correct?
I believe that's correct.
Yeah.
Notice how the questioning tightens. Contact with Lerner, meetings about nonprofits, Second Amendment groups, slow-rolled. Applications. The language here does not require proof to be effective. It relies on association, not causation. Smith attempts to narrow the claim, explaining that he did not target groups and that investigations were separate. But the congressman repeatedly simplifies the answers, compressing nuance into yes or no conclusions. This is a key detail many miss. Complex explanations lose power in public hearings, summaries gain it. The questioning then shifts to prosecutions. Bob McDonnell, John Edwards, Bob Menendez. Each case is framed by its outcome, overturned convictions or mistrials, without discussing legal context. Evolving precedent or prosecutorial standards at the time. By stacking these cases back to back, the speaker creates a pattern, not necessarily a factual one, but a rhetorical one. The phrase "gold standard" is repeated sarcastically, signaling to the audience that praise from the opposing side should be viewed with suspicion. This is not about whether those cases were justified, it's about casting doubt on judgment itself. Then comes the pivot, and it's subtle. After criticizing Smith's record, the congressman asks about alternate slates of electors. This question serves a dual purpose. First, it introduces historical precedent, 1876 and 1960, suggesting that contested electors are not inherently illegitimate. Second, it reframes the January 6 discussion away from intent and toward historical ambiguity. When Smith acknowledges prior instances, the congressman moves to enter the 1960 Hawaii case into the record and is immediately blocked. That objection matters. Because from a narrative standpoint, the moment reinforces the speaker's underlying theme. Context exists, but access to it is restricted.
You also prosecuted John Edwards and Bob Menendez, and those both ended in mistrials, is that right?
The John Edwards case did. The Menendez case, I had left the public integrity section by the time that case was tried. I wasn't.
So, Mr. Chairman, what we heard from the other side here is that this gentleman is the gold standard for prosecution here in the United States. So think about it. We had a witch hunt done by the IRS going after Second Amendment groups, unanimously overturned by the Supreme Court, prosecuted two prominent political figures, and they ended up as mistrials. That's the gold standard here in America? I would just say this, Mr. Chairman. If Mr. Smith ever works for the Department of Justice again, I would recommend a remedial course on the First Amendment to the Constitution. Before I yield the rest of my time, Mr. Smith, I just have one other question. Is there any historical precedent for an alternate slate of electors to be sent to Congress? Has that ever happened before?
That had happened, not anything similar to this situation, but you're correct, it was in Hawaii. I think it was Hawaii in, I want to say the 1960 election.
So it has happened before that there was an alternate slate of electors that was sent to Congress, which does the electoral count, correct?
There was a prior time that an electoral slate was sent where there was litigation and recounts going on.
Actually, there's twice that it happened, Mr. Chairman. It happened in 1876 and 1960 that these alternate electors happened. I'd like to ask unanimous consent to introduce the 1960 Hawaii case.
Again, this exchange is not aimed at changing Jack Smith's answers. It is aimed at shaping how the audience remembers his career. This wasn't a legal cross-examination, it was a historical framing exercise. And in moments like this, the fight isn't just over what happened, it's over which version of the past gets remembered. If you found this analysis helpful, you're welcome to subscribe. New videos here focus on understanding American politics beyond the noise. Thanks for watching, and I'll see you next time.